Court ready?
All right. So judgment, these all stop in your hand for my format.
I hand down judgment in this case, neutral citation number 2021 EWCA Civ 786. For the reasons given in judgment, we allow the appeal against the order of His Honour Judge Jarman.
Appeal in the matter of broadcasting investment group limited and others and Smith and others.
Good morning. First of all, just to say, you can assume that we have all read everything and therefore au fait with your arguments and the relevant parts of the authorities and the facts. And with that, perhaps you'd like to get started.
I'm very grateful, my lady. As you'll know, my learned friend Mr. Sullivan appears for the respondent, cross-appellant, Mr. Smith. He appears with Miss Chilaeva. I appear for the appellant, BIG, and the third claimant, Mr. Burgess, who is the respondent to Mr. Smith's cross-appeal. Might I just check, my lady, if it's permissible, those who are watching by remote link would wish to be able to WhatsApp my solicitors, and I think that's true on the other side of the court. And I understood that ordinarily to be prohibited, but I would just seek the court's permission for it.
I can't see that there's any difficulty with that, and everybody else is content. Thank you.
I'm very grateful. If I might begin then by addressing timings. Subject to the court's approval, Mr. Sullivan and I had provisionally agreed that I will have until 12:30. He will then have until 3:45, followed by my submissions in reply. Again, subject to the court's approval, we propose to deal with the issues raised by the appeal and cross-appeal at the same time. So I will open my appeal and explain my opposition to the cross-appeal. I should say that on that basis, Mr. Sullivan theoretically might require a brief opportunity to deal with any new points that I make on his cross-appeal in reply, but I hope that possibility will remain a theoretical one. My lady, might I just check in what form each of your ladyship and lordships has the joint authorities bundle? Because I understand, are you working from hard copy? Or?
I've got hard copy.
I'm grateful. I'll try to make sure I give tabs, but apologies if I forget. Are there any other preliminary matters that I can usefully address?
No, not for me.
I'm grateful. My lady, I'm grateful for the indication as to the reading that the court has done. As you will know, this appeal concerns the scope and effect of the rule in prudential.
Before you say any more, I'm just slightly concerned that I have a little screen here which says recording, and it also says pause, and I don't know whether it ought not to say pause and whether I am expected to do anything about it. So I'm just checking. Excellent. Wonderful. I didn't think I had to touch anything. That's good.
I think the green light
exactly
means that your ladyship is broadcast around
into the world. Exactly. But I was just concerned when I saw pause that perhaps I had inadvertently done something I ought not to do. Please, I'm sorry to have interrupted.
Not at all. I'm pleased that's not the case. So, as I was saying, this appeal concerns the scope and effect of the rule in prudential, formerly known as the rule against reflective loss. I'll refer to it in my oral submissions as the rule, unless I indicate otherwise. The rule was restated and explained by a bare majority of the Supreme Court last year in Marex. The minority doubted the existence of the rule. Lord Sales, with whom Baroness Hale and Lord Kitchen agreed, said the logic in prudential on a critical examination is not sustainable. Just for your note, that's at 194 of the decision, and see also paragraph 211. But while the majority in Marex preserved the rule, they also circumscribed it tightly. Lord Reid said in terms that the rule had a narrow ambit. That's at paragraph 51 of his lead judgment. And he deprecated the expansion of the supposed reflective loss principle beyond that narrow ambit. As Lord Reed made clear in his lead judgment, the sole effect of the rule is to prevent certain types of loss that are suffered by a shareholder from being recognised, where the company in which they are a shareholder has or had a cause of action in respect of a wrong that caused the relevant loss. The losses in question are two. First, diminution in the value of the shareholder's shareholding. And second, a reduction in dividends or other distributions that the shareholder receives or would have received by virtue of their shareholding. That is first stated at paragraph 9 of Lord Reed's lead judgment. But despite your ladyship's indication, I was proposing to go through Lord Reed's judgment in some detail to draw out the most relevant passages, or what I say are the most relevant passages. I will refer to those types of loss as respectively share value loss and distribution loss. So when I use those terms, it's those types of loss to which I'm referring. If a claim is not by a shareholder or does not depend on establishing either share value loss or distribution loss, the rule in prudential cannot apply to it. The effect of the Supreme Court's decision in Marex was to recast or restore the rule in prudential to reverse its misguided expansion. That's very clear from Lord Reed's judgment. He explains that an erroneous understanding of Lord Millet's judgment in Johnson led to an unprincipled and unjustifiable expansion of the rule. And as I said, the minority would have abolished the rule altogether. So properly understood, the majority's decision in Marex is to confine the rule very strictly indeed. The decision of the learned deputy judge involves an immediate expansion of the newly circumscribed rule to a potentially massive corpus of cases involving contracts concluded by a shareholder for the benefit of a company. Whether that company is as yet to be incorporated or is already incorporated, if the learned deputy judge is right, then where the company is not a party to the contract, but a shareholder is, the rule would bar the shareholder's claim. And that claim is a claim as contractual promisee. As I'll come on to show you, it is a fundamental principle of contract law that a contractual promisee ought to be able to enforce a contractual promise made to them, absent very rare exceptions. If I might explain the proposed structure of my submissions, after saying a very few words about the alleged contract to which these proceedings relate, given my lady's introductory remark, I will explain why the rule in prudential can never bar a claim for specific performance or damages in lieu of specific performance. That is the subject of ground 2 of this appeal, for which Lord Justice Newey gave permission. I will then address the Contracts, Rights of Third Parties Act, which I'll refer to as the 1999 Act, and explain why, on the proper construction of the 1999 Act, a claim by a contractual promisee who happens to be a shareholder in a company can never be affected by a company acquiring a right to enforce the contract by operation of Section 1 of the 1999 Act. That's the essential point at the heart of ground 1. The conferring of a right under Section 1 can't take away the promisee's primary right to enforce the contract. That is the subject of ground 1 of the appeal, which the learned deputy judge, Andrew Simmonds QC, himself gave permission to advance. Next, I will deal with the different or additional ground on which Mr. Smith seeks to uphold the order striking out BIG's claims under the agreement. He seeks to do so on the basis that on the facts assumed by the learned deputy judge, SS plc, in which BIG is a shareholder and to which I will refer as the company, would have had a claim against Mr. Smith for breaching his fiduciary duties as its director by failing to perform his obligations under the agreement. Those were obligations that he owed in his personal capacity. They were not obligations he owed qua director. One obvious way of verifying that is the company did not exist when he undertook the obligations, and so he wasn't a director of the company. He undertook those obligations in his personal capacity, and he only ever owed them in his personal capacity. I will refer to the respondent's notice ground for upholding the order as the hypothetical fiduciary duty claim. And I should say, although I don't complain about this particular fact, or don't complain too loudly about this particular fact, it was really a footnote or an afterthought at first instance that has then taken on tremendous significance.
Well, it's only a paragraph, I think, in the judge's judgment.
It's only a paragraph in the judge's judgment. It was nowhere. What I absolutely do say about it is that the judge's decision to allow the claims to progress to trial, notwithstanding the possibility of the hypothetical fiduciary duty claim engaging the rule in prudential, was a discretionary exercise of the learned deputy judge's case management powers. It was obviously a reasonable exercise of that discretion. I would say it was plainly a right exercise of that discretion, but of course I don't need to persuade my lady and my lords of that. I need only persuade you that it is within the ambit of the generous discretion afforded to the judge. So my primary submission is that this court should not entertain the ground on which my learned friend seeks to rely as an additional ground for supporting the order. It can dismiss that argument out of hand, because to do otherwise would be to interfere with an exercise of the judge's discretion on a strikeout application, which is an unimpeachable exercise of discretion. And I cited Rees Brintrim as authority for the proposition that the court should not reopen that kind of a discretionary decision absent a clear identifiable flaw underlying it, and in particular on paragraph 76 of Sprintrim. But I trust that my lady and my lords are familiar with that decision, so I won't take you to it at this stage. I should mention one further point about the hypothetical fiduciary duty claim at this juncture. It's related, of course. This appeal is a review, not a rehearing. And it is not open to Mr. Smith to rely on a pleading that was not before the learned deputy judge. He's produced a pleading since then and says in summary, well, the learned deputy judge said there was no pleading before him. Here's a pleading. So now you can strike out the claim based on the fiduciary duty claim that I've now pleaded. That's wrong in principle. In my submission, this court should not have regard to the defence. But if you're against me on that, I'll show you why the defence doesn't cause or shouldn't cause the court to doubt the exercise of the judge's discretion. So even if you're against me on those two threshold points as regards the hypothetical fiduciary duty claim, I say the attempt to rely on it is misplaced. And finally, I will address the cross appeal. By the cross appeal, Mr. Smith challenges the learned deputy judge's decision not to strike out Mr. Burgess's claims under the agreement. His only claim under the agreement is a claim for specific performance or damages in lieu of specific performance. He does not claim contractual damages as distinct from damages in lieu of specific performance. That claim is nowhere in the pleading, and I made a mistake in my skeleton that I need to correct, but it's clear on the face of the pleading and indeed was noted by the judge that Mr. Burgess makes no claim for damages. No part of his claim is a claim in respect of...
Sorry, which paragraph are you correcting?
My Lord, sorry, I was going to come to it in a moment, but the paragraph is paragraph 11 at C25. And it's the penultimate line, and it should be struck through because the only respect in which he seeks damages at one stage removed is damages in lieu of specific performance. And that actually isn't at one stage removed because he is a party to the contract and a promisee. And so he has the primary right to seek the equitable remedy of specific performance or damages in lieu of specific performance. So I apologise for that mistake. But the point that I was making is, because no part of his claim is in any way dependent on establishing share value loss or distribution loss, he doesn't plead either type of loss. The rule in prudential cannot apply to bar his claim. And the other unanswerable reason why the rule cannot apply to bar his claim is that he is not a shareholder in the company. And I will come on to deal with what I characterised in my skeleton as the Russian doll fallacy in my learned friend's case, that because Mr. Burgess is the shareholder of a shareholder, the rule applies to him. And I will endeavour to show the court that on a proper reading of Lord Reed's judgment and Lord Hodges' concurring judgment, that argument doesn't run. Sorry, my lady.
No.
So I say that the cross-appeal can be dismissed in a sentence. The rule in prudential has no application to Mr. Burgess's claim under the agreement because he is not a shareholder in SSPLC and his claim is not a claim in respect of share value loss or distribution loss. But I'll flesh out these points in due course. So the agreement then, my lady, I should note that a number of matters are highly contentious, but it goes without saying that at this stage and on an appeal from a strikeout application, the facts pleaded by BIG and Mr. Burgess are assumed to be correct. So I'm stating the facts as pleaded by BIG and Mr. Burgess. The agreement was made on the 30th of October 2012. It was an oral contract. For the court note, it is pleaded at paragraphs 18 to 24 of the re-amended particular claim, which paragraphs have not been amended since the particular claim were served. And the bundle reference is tab 9, 104. When I give references, they'll be to the core bundle unless I say otherwise. The parties to the agreement were BIG and Mr. Burgess on the one hand, and Mr. Smith and Dan Finch on the other. As I've said, at the time, SSPLC did not exist. Significantly...
So just can I ask you a question about that? Because it's obviously an important fact in the present case that the contractual obligation relied upon came into existence before the company came into existence. Now, am I right in thinking that in that respect, this case is unprecedented? I can't claim to have looked through all of the authorities on the rule of prudential, not even all the ones that are cited or are in the authorities' bundles in great detail, but I haven't spotted one so far with that fact pattern. Is that right?
My lord, I have found none in my researches. I never give warranties about the non-existence of cases, but I've been unable to find any such case. And I do say it's a significant factor in at least two respects. I was about to identify the first, but I won't keep your lordship waiting for the second. The first respect in which it is significant is that it is no part of BIG's or Mr. Burgess's case that anyone contracted as agent for the as yet unincorporated company. They could have done, and Section 51 of the Companies Act provides for what would have happened if they had done. But on BIG's and Mr. Burgess' case, they made a deliberate decision not to. So they decided not to make the company a party to the contract, not to contract on behalf of the as yet unincorporated company. And the result of that is that the company never had any primary rights under the contract, and no one ever intended it to have any primary rights under the contract, because no one ever intended it to be a party to the contract. And I'm sure the court appreciates, but why I'm referring to primary rights under the contract is to distinguish them from rights that can be conferred by the 1999 Act by Section 1, and that is a secondary or accessory right under the contract. So it's a right conferred on a third party to enforce the contract. And the learned deputy judge found that the criteria for conferring a right on SSPLC were satisfied in relation to the agreement, and I don't seek to challenge that finding. But that finding is obviously and crucially distinct from a finding that the company was ever intended to acquire primary rights or owe primary obligations under the contract. So that's the first respect in which I say it's very significant that the contract predated SSPLC's incorporation. The second respect in which I say it's significant, I'll come on to in due course, but just to give you a prelude of the point, is that it's no part of the bargain that the shareholders, or the future shareholder, BIG, made in contracting with Mr. Smith and Mr. Finch, that its primary contractual right would be subsumed by SSPLC's secondary contractual right under the 1999 Act. And a curious thing about my learned friend's position and the learned deputy judge's conclusion as to the 1999 Act is that Section 4 of the Act provides expressly that the conferring of a right under Section 1 cannot affect the right of the promisee, the person with the primary right. And yet, if the learned deputy judge is right about the 1999 Act, Section 1 doesn't just affect BIG's right, it negates it. It leaves BIG with no right to enforce the contract. And I say that's contrary to the clear wording of the statute, but we'll come on to that in due course. And my lord, there is actually a third reason why timing is highly significant in my submission. It's a point that I've made in my skeleton, but to which I'll return in my oral submissions, which is because SSPLC did not exist, if Mr. Smith had completely failed to perform his obligations, one of his obligations was to incorporate SSPLC, then if my learned friend and the learned deputy judge are right, BIG could happily have brought a claim in contract for damages or specific performance, but it somehow lost that right once SSPLC was incorporated. So it had a perfect contractual claim, and then it was deprived of it, notwithstanding the wording of Section 4, by the incorporation of SSPLC. And I say that cannot be right. And in my respectful submission, it would create an absurdity when one considers the claim for specific performance. Because, as I just said, pre-SSPLC's incorporation, BIG could have sued for specific performance of the contract to which it was promisee. But what order would the court make if it thought it were equitable to intervene in the contract and in the threat of Mr. Smith not performing his obligations?
Yeah, now in that context, can I just flag up something which I'm not expecting you to address straight away, but I would like you to come on to at a convenient moment in your submissions, which is whether the true remedy in these circumstances is a derivative action.
My Lord, I will of course address that, but to just give my answer in a nutshell, I say that while there might be derivative claims available on these facts, that does not mean that it is the only answer. And derivative claims are one permissible route allowed by the principle in Foss and Harbottle. And I'll come on to the principle in Foss and Harbottle, but my lady and my lords will be familiar with it. But what I say is, on a proper understanding of the principle in Foss and Harbottle, which is the underpinning of the rule in prudential, it doesn't remotely bar a claim by contractual promisee when the company is not a party to the contract. The principle in Foss and Harbottle, as summarised by Lord Reid in Marex, is that when you become a shareholder, you entrust to the decision-making organs of the company in which you are a shareholder the management of the company's rights of action. On these facts, the company doesn't have a primary right of action or cause of action under the agreement. BIG does. That right of action, the primary right of action, never vests in the company. On no reading of Section 1 and Section 4 does Section 1 vest the promisee's right in a third party to the exclusion of the promisee. So because the right of the promisee never vests in the company, the promisee is not entrusting the management of that right to the decision-making organs of the company. The primary right remains all times vested in the promisee, as it remains vested in BIG in this case. So in answer to BIG and Mr. Burgess, I should say, so in answer to my Lord's question, BIG should not be required to bring a derivative claim to enforce SSPLC's Section 1 secondary right, because it has a more direct route. It can just enforce its primary contractual right. And as my Lord will know, it couldn't bring a derivative claim without leave of the court. And as I said a few minutes ago, it's a fundamental principle of contractual law that a promisee ought to be able to enforce the promises made to them. And to put in the way of a promisee the hurdle of seeking leave to bring a derivative claim would, in my submission, be contrary to principle and wrong. So I hope that will suffice as a short-ish answer to my Lord's question, but I'll return to it while I address your Lordship on the rule or the principle in Foss and Harbottle. I may well get my principle and rule muddled up, but I'll try to stick to the rule in prudential as the rule and the principle in Foss and Harbottle as the principle, because that's the terminology that Lord Reid used.
Another question which I'd like to identify at an early stage, and again, I'm not expecting an immediate answer, but we have to take into account, is the fact that the company is in liquidation in the present case. Is that relevant, and if so, how? Or do you say it's completely irrelevant?
I say, on the facts of this case, it's completely irrelevant because of the, I will just be repeating myself, but the nature of BIG's primary contractual right. So, in fact, the company's claim that, as things stand, only the liquidator could bring is time-barred.
Sorry,
Is time-barred, statute-barred, my lord. But that doesn't matter. I'm not suggesting that it matters, because Marex and the decisions that Marex approves make clear that the fact that a cause of action is no longer available to the company doesn't prevent the rule in Prudential from being engaged in certain circumstances. But I was only mentioning it for my ladies and my lords' knowledge, really. The point that I was making is the decision of the liquidator, or before him, the decision of the directors, as to whether to enforce the company's secondary right under the Act is wholly independent from BIG's or Mr. Burgess's decision as to whether to enforce their primary rights under the contract. And obviously the company's decision as to whether to pursue the hypothetical fiduciary duty claim is distinct as well, and I would say even more distinct from the question of whether BIG and Mr. Burgess should enforce their primary right. I ought just to mention one point on the hypothetical fiduciary duty claim, which is that Mr. Smith should be careful what he wishes for, because if he has committed the breach of hypothetical fiduciary duty that he says he would have done on BIG's and Burgess's facts, he would have committed a breach of fiduciary duty, breach of director's duty, that this court characterised in first sub-C as a fraudulent breach of trust. And so there'd be no limitation period at all as regards that claim. But that's just a note that I make in passing. The answer to my Lord's question is, on the facts of this case, it doesn't matter that SSPLC is in liquidation, because BIG's and Mr. Burgess's rights are distinct from the company's. For the reasons that I will elaborate shortly, the claim-specific performance cannot engage the rule in Prudential, and on a proper interpretation of the 1999 Act, the conferring of a right on the company by Section 1 cannot bar BIG's claim in damages either. So, my lady, my lords, I was trying to take the facts very briefly, but those interventions were tremendously useful and welcome. I don't know how much I really need to say more about the agreement. I had just said how significant it was that the parties did not choose to contract on behalf of SSPLC. In fact, I think I was just about to say that when my Lord Justice Arnold asked his first question. I should just remind the court, however, of the obligations that Mr. Smith undertook under the agreement. The first was what I'd call the incorporation obligation, to incorporate SSPLC. The second was to procure the allocation of 39% of the shares in that vehicle to BIG. That was the allocation obligation, as I've called it. And third, to procure the allotment and or transfer of the entire share capital of two broadcasting technology companies, SS Limited and TVP, to the joint venture vehicle, which is, as it turned out, the company. Mr. Smith duly performed the incorporation obligation and the allocation obligation. He incorporated SSPLC on the 20th of November 2012 and procured the allotment of 39% of the issue shared therein to BIG by the 28th of December 2012. But Mr. Smith failed to perform the transfer obligation, which is why I am before my lady and my lords. The claims to which the appeal and cross-appeal relate are BIG's claims for specific performance of the transfer obligation, alternatively damages in lieu of specific performance, and Mr. Burgess brings a mirror claim that the learned deputy judge did not strike out, and I say he was right not to strike it out. And the second claim is a further alternative claim by BIG for contractual damages for breach of the agreement. And I say candidly, the damages that BIG seeks as pure contractual damages, as distinct from damages in lieu of specific performance, are damages for share value loss and distribution loss. So, if this court could safely conclude that the company had a cause of action in respect of the loss of which BIG's claim loss is reflective, then the rule in prudential could be engaged. But I say, as regards the hypothetical fiduciary duty claim, the court cannot at this stage safely conclude any such thing, and I'll elaborate that submission in due course. And as regards the 1999 Act claim, the rule in prudential is not engaged because Parliament provided in Section 4 of the Act that Section 1 couldn't affect the right of a promisee.
Now, two questions arising out of that. The first one is specific performance a realistic remedy in the circumstances of this case? Secondly, if we look at damages in lieu, would I be right in thinking your clients that seek to quantify damages in lieu on the same basis as their ordinary contract?
My Lord, I'll deal with the first question first, if I might. I say specific performance. This was a point that was canvassed before the judge, and an argument that Mr. Sullivan made was that specific performance was not possible or was not wholly possible, but the judge did not accept that argument on a strikeout application, and that is not a matter before my lady and my lords today. So I say actually that's an end to the point. But in answer nonetheless to my Lord Justice Arnold's question, I say specific performance is certainly, on the facts as we understand them, at least substantially possible, because Mr. Smith and Mr. Finch, who is another of the defendants and another of the parties to the agreement, held shares in the companies that they were obliged to transfer to SSPLC. So partially capable performance. And I say that it is at least arguable that the trial judge will consider it equitable, because specific performance is an equitable remedy, and we'll see that in the authorities, to order as much specific performance as it's possible for the defendants to deliver, and then damages in lieu. Which brings me to my Lord Justice Arnold.
Before you get on to the second question, I'm grateful for your answer to the first question. What's the effect of that? Let's assume that the remedy is granted, and let's also assume that we can ignore any potential complications and it's then complied with. What happens? The shares get transferred to the company in liquidation.
Yes.
And what do? You claim it for a distribution in the liquidation?
Well, BIG is a shareholder, so
Well,
BIG
exactly.
is... Yes.
So you will hope there will be a surplus on the liquidation that you will then claim a distribution.
My Lord, yes, absolutely. But that is just a consequence of what I have said already, which is that a promisee who contracts for the benefit of a company is entitled to enforce the contractual promise that is made to them. And it doesn't begin to bar the claim to say, oh, well, but your contract benefits the company, and in due course you might benefit from the company being benefited. Because the focus is on, first, the contractual right of the promisee, and second, as I'll show you in Lord Reed's judgment, whether the claim by the promisee depends on establishing either share value loss or diminution loss. If the claim does not depend on establishing one of those types of loss, the rule is not engaged. Because
takes us on to my second question.
Absolutely. Sorry, and my Lord, if I just might finish that thought on your first question. So the rule is not engaged, and the reason why that is really significant is, as Lord Reed makes abundantly clear, the rule is not about nullifying a cause of action or right of action. It does not deprive a shareholder of a claim or fail to recognise the claim. It fails to recognise those very specific types of loss. So as a matter of logic, it's only claims that depend on those specific types of loss and exclusively on those types of loss that can be barred by the rule. So one can imagine a claim partly for those types of loss and partly for other types of loss. And the claim for the other types of loss would sail on happily through to trial. But the claims for share value loss and distribution loss would engage the rule and therefore be barred. And so, my lords, second question, the damages in lieu of specific performance would absolutely not put BIG in the position that it would have been in had it just succeeded in its pure contractual claim. Not least because the pure contractual claim includes a claim for distribution loss. So the dividends and distributions that BIG says it would have received if Mr. Smith had performed his contractual promises. And succeeding on the specific performance claim or the damage in lieu of specific performance isn't going to get back for BIG the distributions that it otherwise would have got. And as regards the value of BIG's shareholding, BIG, if the liquidation ends up being a solvent one, BIG might get some value for its shareholding. But that does not mean that its claim for damages in lieu of specific performance is a claim in respect of value loss, because it is not a claim that depends on value loss. The thing that a claim for damages in lieu of specific performance depends on is specific performance being a just and equitable remedy, but being wholly or partially incapable of performance. So, as I'll show you on the authorities, my Lord Justice Arnold, loss just doesn't come into the picture on a claim for specific performance, other than as a discretionary factor when the court's considering whether to grant it. And because loss is no element of the claim, the rule in prudential can't be engaged. And I would say that to look at the ultimate consequence of damages in lieu of specific performance being awarded is to look at the question through the wrong end of the telescope. Lord Reed makes clear claims by shareholders are fine unless they are claims in respect of share value loss or distribution loss, and the company has a cause of action in respect of the loss of which those losses are reflective. So unless those conditions are satisfied, there's no application of the rule. And in my submission, it's wrong in principle to say, well, the ultimate effect of the remedy that might be granted on a claim that in no way depends on loss is to provide some kind of compensation for that loss. And of course, my Lord, the damages in lieu of specific performance would be payable to either BIG or to the company. And because specific performance is an extra remedy and because of the flexibility that the court enjoys, the court could be very alive indeed to any concerns that it might have about the remedy that it ultimately granted, offending against any of the principles that Lord Bingham explained in Johnson. And I mentioned that because Lord Reed in Marex approved Lord Bingham's reasoning. The court can look at those matters when it comes to exercise its discretion if it decides that specific performance or damages in lieu should be granted or might be appropriate to grant. But it would be inappropriate and wrong at this stage to strike out a claim because ultimately it might have the result of indirectly compensating for BIG for one of the types of loss that the rule in prudential relates to. So specific performance then and ground two of the grounds of appeal. if I might just remind my lady and my lords of that ground as it's framed. So in the core bundle, tab 1, page 12, I won't read it aloud unless you wish me to do so, my lady, but I would just emphasise the second sentence. The deputy judge should have held that the rule in prudential can never bar a claim for specific performance or damages in lieu. Alternatively, did not bar the appellant's claim for specific performance or damages in lieu in this case, because such claims are not claims in respect of the diminution in the value of a shareholding or reduction in the distributions received by a shareholder. So that is the point stated in a sentence, and I will seek to make good that ground, principally by reference to the lead judgment of Lord Reed in Marex, and I'll also just take the court if it would assist to only a couple of authorities on specific performance. I'll take this as much of a canter or a trot or a gallop as the court indicates, given my lady's initial indication, because I expect that my ladies and my lords' focus will have been squarely on Lord Reed's lead judgment. So please do speed me along or slow me down as you see fit. I would start with paragraph 9.
I'm sorry, so we're in the...
Oh, sorry, I'm sorry. You said hard copy and I ignored you, my lady. So tab 17. Do you have it, my lady, my lords?
We do, so you were taking us to...
Paragraph 9 first. So this is in the lead judgment of Lord Reed at page 56. I won't just read paragraph after paragraph aloud, my lady, but I would again just emphasise the...
So you'd like us to read paragraph 9?
Please, my lady, and with particular emphasis on the second sentence. There is, however, one highly specific exception.
Yes.
So it's a highly specific exception, my lady, and an exception that only applies to claims in respect of what I've called share value loss and distribution loss. It is a rule of company law. It is not a rule of damages. It is not a rule of any wider ambit. So this is the first paragraph that reinforces my submission that Lord Reed is tightly circumscribing the rule. The next passage to note in particular is the second half of paragraph 10. So after Lord Reed says that aspect of the rule is understandable on the basis of the reasoning prudential, if you would read from there, my lady, to the end of that paragraph.
Thank you.
So the sole effect of the rule is to prevent the shareholder's loss from being recognised. That's what I said earlier in response to my Lord Justice Arnold's question. It has no other impact. It's only to prevent the recognition of certain types of loss. And as I said earlier, the principle on which the rule is based, the principle that underpins it, is the Foss and Harbottle principle. And Lord Reid summarises it as stating that the only person who can seek relief for an injury done to a company where the company has a cause of action is the company itself. So it's a principle that applies when an injury is done to a company. And in my submission, breaking a primary obligation to a promisee is an injury to the promisee, first and foremost. And it's a different injury from the injury that might be said to have been caused to a company that happens to have any secondary entitlement under the 1999 Act. So the principle in Foss and Harbottle, as explained by Lord Reid or summarised by Lord Reid, it is entirely consistent with and supports the rule in Prudential only applying to preclude the recognition of certain types of loss. The effect of the principle in Foss and Harbottle, as explained in Prudential and quoted by Lord Reid at paragraph 37, though we needn't go to it just at this moment, is that the shareholder accepts that the value of his investment follows the fortunes of the company. So when a shareholder invests in a company, they understand that a diminution in the value of their shareholding or a reduction in the distributions they receive is not something they can bring a claim in respect of in the ordinary course. But going back to, I believe, my Lord Justice Arnold's first couple of questions, it's one of the reasons why I say that the lack of existence of SSPLC is a significant factor, but also a reason why I say BIG's freestanding rights as promisee are another relevant factor. It just wasn't binding up its rights as promisee with the fortunes of the company in the same way as a shareholder implicitly accepts that they won't be able to claim for lost dividends if the company is the victim of a tort, for example. In those circumstances, my Lord Justice Arnold, the only remedy would be a derivative claim if the shareholder wanted to seek to pursue or cause the company to pursue a claim, unless, of course, it was unfairly prejudicial to the shareholder for the company not to pursue the claim. If I might then ask my lady, my lords, to read paragraph 26 of Marex. Just at the bottom, so over the page on page 60, you'll have seen, sorry, I oughtn't to have asked you to turn the page quite so fast. The quote from Prudential that begins at the bottom of the previous page carries on onto page 60. And what I wanted to emphasise was Lord Reid explaining that passage and saying it makes clear that the decision was concerned only with what I've called share value loss and distribution loss. It was not concerned with other losses suffered by a shareholder or with situations where the company had not suffered any actionable loss. And so, my lady, my lords, I say again, if Section 4 of the 1999 Act did not exist, and if the company had acquired a right under Section 1, I might be in difficulty, but I wouldn't accept that I would be in difficulty. But I don't need to persuade you of that because of Section 4. And that will, of course, be something I address you on further in relation to ground 1. The next passage, just to note, is at 28, the second half of 28, if I might just ask my lady, my lords, to read that as well. So, beginning as I understand its reasoning. So that's another restatement that the rule is about not recognising share value loss and distribution loss. And I apologise that this is going to become repetitive, but it's something of a half-hearted apology, because it's very important that Lord Reid keeps saying it's about not recognising those types of loss. Because my learned friend, in trying to say, oh no, my understanding of the rule is wrong, has to build his case on just a couple of flimsy pillars, whereas again and again, the motif of this judgment is it is about not recognising those two specific types of loss in certain circumstances. So if a shareholder, oh, sorry, I should have taken you to 35, my lady. And if I might ask you just to read that paragraph until the sentence beginning the second aspect of the rule.
Well, I think we possibly all read that because it's festooned with marking outside.
I'm grateful, my lord. So, my lady, my lords, if a shareholder is a party to a contract, but the company is not, then absent the operation of the 1999 Act, only the shareholder can enforce the contract. And the shareholder in those circumstances is perfectly entitled to claim damages for breach of contract, including damages for value loss and distribution loss. That is made explicit by Lord Reid at paragraph 45 of his judgment. I saw my lady frown, so I'll go there now and then return to the 30s of the paragraphs. But it's Lord Reid explaining George Fisher, which is a pre-1999 Act decision. But I say that doesn't matter, other than because there was no consideration in that case of the interrelationship between sections 1 and section 4. But my lady will see that Lord Reid there makes good what I just submitted. Because the company had no cause of action, because it wasn't party to the contract, the shareholder promisee was perfectly free to recover contractual damages for share value loss and distribution loss. And my lord, this is very significant in respect of, I'm afraid I don't remember which number of question it was, but where you were taxing me on the ultimate effect of damages in lieu of specific performance. There's no problem with the ultimate effect of a remedy being compensation for share value loss or distribution loss in certain circumstances. The rule in Prudential doesn't say that kind of loss can never be compensated for other than by a derivative claim. And George Fisher and Lord Reid's explanation of that is a demonstration of that.
If the company had no cause of action.
If the company had no cause of action, my lord. So, going back to this case, you've heard my submissions on the hypothetical fiduciary duty claim, so that can just be left to one side, should be left to one side. So one is dealing only with the 1999 Act as regards BIG's claim for damages. And I say...
So what about this case? Because at the time the contract is made on the assumed facts, the company doesn't exist. Subsequently, the company comes into existence, and upon coming into existence, instantly acquires a cause of action under Section 1.
Yes, my lord. Well, instantly acquires a cause. Doesn't quite instantly acquire a cause of action. Acquires a cause of action as soon as Mr. Smith fails to perform the transfer obligation. But it does at that. It acquires a right to enforce the contract instantly. And Section 4 says the acquisition of that right can't affect the promisee's right. It's as simple as that. And so because the conferring of the right under Section 1 can't affect the promisee's right, in response to my Lord Justice Coulson's observation, while the company has a cause of action under Section 1 of the Act, it is not a cause of action that can engage the rule in Prudential. Because if it were a cause of action that engage the rule in prudential, then Section 1 would be doing what Parliament expressly said it can never do, never in any circumstances. There are no exceptions or carve-outs to Section 4. And with great respect to the learned Deputy Judge, he described my submissions as suggesting that the statute would override the rule in prudential. And I say that's the wrong analysis. The correct construction of Sections 4 and Section 1 read together, and Section 7 is also relevant, as I'll come on to explain, is to prevent the rule from ever being engaged. So there's no rule to override, because it's not engaged, because Parliament said that the right of the promisee can never be affected by the conferring of a right on a third party. But of course, even if I'm wrong about that, or you dislike my suggestion that overriding is the wrong concept, it need hardly be said that statute does override common law. So where Parliament expressly states that a provision can't have an effect, that the court is bound to give effect to the legislature's intention. My lady, I went to 45 because I saw my lady frown. But if I might then go back to 35. And I was just, I think had invited the court to read until the sentence beginning the second aspect. And my Lord Justice Coulson said that had been well highlighted. Then next is at the bottom of 37, just to note the quote from Prudential that I mentioned to my lady, my lords earlier is there. And you'll recall the submission I made about a shareholder promisee's fate not being relevantly bound up in the fortunes of the company. And then the next point I would invite my lady and my lords to read is at 39. And this is another statement that it's not recognised by law. In the eyes of the law, in certain circumstances, share value loss and distribution loss are just not loss that a shareholder can bring a claim in respect of. But of course, specific performance has nothing to do with loss. If, as in the case of a claim for specific performance, share value loss or distribution loss play no part in the cause of action, then the sole effect of the rule in Prudential, which is to prevent recognition of those types of loss, is irrelevant. That's why I called the rule and a claim for specific performance ships passing in the night. At paragraph 52 then, I hope, am I taking this at a roughly acceptable speed, my lady?
I'm content.
I'm grateful.
52.
52. Actually, just pausing at 51 for a moment. This is really relevant, more relevant to the cross appeal, but it's Lord Reed's reference to the unique position in which a shareholder stands in relation to his company. I just highlight that so that I don't have to come back to it later. It's a position unlike the position of someone who happens to hold shares in a shareholder of a company, because someone who happens to hold shares in a shareholder of a company enjoys none of the rights and entitlements that a shareholder does, and those rights and entitlements are discussed in detail by Lord Hodge, as I will show my lady in due course. And also just to note that Lord Reid is deprecating the double recovery justification for the reflective loss principle as it was called. And then 52, which is what I initially was going to ask my lady to read, if you might read that entire paragraph, please, and then I'll make some submissions in relation to it.
Yes.
So a yet further statement that unlike the principle against double recovery, the rule in Prudential denies the existence of the shareholder's loss. So it's a kind of legal fiction. The shareholder has suffered no loss that the court recognises. And then Lord Reid says, and this is really important because my learned friend and indeed the learned deputy judge placed significant weight on paragraphs 52 to 54. Lord Reid says, well, the problem with analysing what was called the rule against reflective loss as about avoiding double recovery is that it enables a shareholder to bring a claim based on irrecoverable loss as long as they tailor their remedy appropriately. And then Lord Reid disapproves in passing 3 decisions.
When you say in passing, I mean, he does rather disapprove of them.
I'm absolutely, my lord. The reason why I say in passing...
Because I think in your skeleton you use the word fleeting, and I did rather wonder what a fleeting disapproval might be.
Well, my lord, it's fleeting in the sense...
He doesn't like them because he thinks they're a device. But your point is this is all related to it being concerned with the rule against double recovery, which itself is not the principle that the rule in Prudential is based on.
My lord has it exactly. So I was just going to say fleeting in the sense of occupying a paragraph, but beyond and fleeting is not just rhetoric, my lord, because there is no detailed analysis of the facts of these the decisions that he disapproves in passing, and so it's dangerous in my submission to read too much into the disapproval, and the disapproval in my submission must be read in the context that my Lord Justice Coulson just mentioned. So Lord Reid has explained that, analysing what he no longer calls the rule against reflective loss as being about avoiding double recovery can lead to difficulty. And then he gives 3 cases where difficulties ensued, but the criticism is focused on the problems with the double recovery analysis. In Peak Hotels, it was a fraud claim, and it should have been a derivative claim, and the claimant sought, in the alternative, an injunction requiring property to be restored to the company. And that was just as an alternative remedy in respect of a cause of action that was certainly vested in the company. So one can see why Lord Reid did not like it. And I wonder, I might wait to hear exactly what my learned friend says about these and come back to them in reply, but just in terms of Latin American Investments in brief, it was an application to set aside a freezing injunction, and what happened was that it was argued that there was no good arguable case because the claim was barred by what was then called the rule against reflective loss. And Mr. Justice Tier said it was at least well arguable that the rule was not engaged. And Mr. Justice Tier held in particular that it was well arguable that a claim for specific performance was outside the rule. The essential significance of Lord Reed not analysing Latin American investments in any detail is that he did not engage with the fact that a claim for specific performance does not depend on loss. And he said again and again in the passages I've already shown, my lady and my lords, the rule in prudential is only about loss. So going back to my Lord Justice Coulson's point, he's deprecating Latin American investments because its false premise was that the rule against reflective loss is about avoiding double recovery. But if you analyse it properly, Mr. Justice Tier's direct decision was correct, but for different reasons than he gave. With great respect to Mr. Justice Tier, he ought to have held that the claim was a good claim, the claim for specific performance was a good claim, notwithstanding the rule against reflective loss, because the claim for specific performance in no way depended on establishing value loss or distribution loss. So, of course I would say this because this is, in my submission, the only really unhelpful paragraph to my ground 2. It should be approached with great caution. I could not make the submissions that I've just made if Lord Reed had even considered specific performance and explained why somehow a rule that does not recognise loss is engaged to bar a claim that does not depend on loss. But nowhere did he. Then, my lady, my lords, paragraph 66. You'll be relieved to hear I'm not taking any of the other authorities in this much detail. But at paragraph 66, this is really, I'm just flagging it at G, if I might ask you to read from there is no indication. So it's yet further reinforcement for the submission that I made, only about not recognising share value loss and distribution loss. Nothing further. It only ever applies to someone who's actually a shareholder in the company. And then 67, again, if I might ask my lady and my lords to read that. And I would just emphasise in particular the word normally. I'm not suggesting that Lord Reed had in mind, as far-seeing as he is, that this sort of case might occur. But the 1999 Act and the particular facts of this case could be easily characterised as a case that isn't a normal one. It's not a normal one because the company's cause of action is a cause of action that Parliament says can't affect the right of the promisee. So he's not saying, categorically not saying, that the rule always applies to bar these sorts of claims wherever the company has a cause of action. going back to one of my Lord Justice Arnold's questions, the claim for specific performance is not a claim that BIG is bringing in its capacity as shareholder. It's bringing it in its capacity as promisee. And if you still have Marrick's open at 66 over on 67, Lord Reed says and explains Lord Bingham as having intended that the rule should be confined to claims brought in the capacity of a shareholder. It is not a claim being brought by BIG as in its capacity as a shareholder. That's why I said to my Lord Justice Arnold that saying it might have a derivative claim doesn't prevent it from bringing its contractual claim. The proof of the submission that it is not bringing its claim in its capacity as a shareholder is that if it had sold its shares, transferred its shares, the moment it received them, it could still have sued to enforce the contract. Because its right to enforce the contract has nothing to do at all with its rights as a shareholder. My learned friend couldn't possibly invoke the rule in Prudential then, because it wouldn't be a shareholder. And it wouldn't be claiming damages for value loss or distribution loss. It would just be claiming specific performance. And it's entitled to do that because it's a promisee and the court enforces contracts. So its claim is not a claim in its capacity as shareholder. I'll come on to show my lady, my lords, Bezic and Bezic, which you may or may not have read in your pre-reading. But that was a case where very unattractively it was argued against the administratrix of an estate that, to whom the appellant had promised an annuity, that the claim for specific performance by the administratrix qua administratrix could not succeed because the estate of the deceased, her husband, had suffered no loss. And so there was no entitlement to specific performance. The loss had been suffered by the administratrix in her capacity, in her personal capacity, in her capacity as the person to whom the annuity had been promised. But because it predated the 1999 Act, she had no direct entitlement to enforce the contract in that capacity. So Bezic and Bezic stands as the highest authority for the proposition that loss is no part of a claim for specific performance. It's not an ingredient that's required to be established. But also it's highly relevant to the hypothetical that I just gave. If BIG had sold or transferred its share away the moment that it became shareholder, there would have been no answer to its claim for specific performance that it hadn't suffered any loss. It could just say, you made a contractual promise and I want the court to enforce that promise. So it's misunderstanding what specific performance is about to say that its claim for specific performance is somehow barred by the rule in Prudential. And then, if I might just ask my lady, my lords, to read 79. And it's really just to highlight, again, the distinction. And number one is about share value loss and distribution loss. And that's what those sorts of claims where the company has a relevant cause of action engage the rule. And claims brought in respect of any other loss don't engage the rule. And that was why I said, well, one can imagine a claim that would be partially barred by the rule if part of the loss was within the rule and part of the loss was without it. But I say, given that any loss outside share value loss and distribution loss is not caught by the rule. A fortiori, a claim that is not dependent on any loss can't be caught by the rule. And paragraph 80, I'll just read what I say is the critical part of it. In case of the first kind, the shareholder cannot bring proceedings in respect of the company's loss, since he has no legal or equitable interest in the company's assets. It is only the company which has a cause of action in respect of its loss. So the rationale that Lord Reed gives for the shareholder not being able to bring a claim in respect of share value loss and distribution loss is that he has no legal or equitable interest in the company's assets. That was one of the things that Lord Reed said was wrong about Lord Millett's judgment in Johnson. That Lord Millett proceeded on the premise that a shareholder did have a legal and equitable interest in the company's assets. But where one's looking at the rights of a contractual promisee in circumstances that involve the company not being a party to the contract, the company has no legal or equitable interest in the contract. It has a right out with the contract, statutory right out with the contract by operation of Section 1 of the 1999 Act. But in direct contradistinction to the first sentence of paragraph 80, it is the shareholder and the shareholder alone who has the primary legal right to enforce the contract, and the right, which is a right in equity properly characterised, to seek specific performance of the contract. So the shareholder has the legal and beneficial interest, legal and equitable interest, I should have said. And any interest that the company derives in the contract is, first of all, a creature of statute, and second, entirely parasitic upon the shareholder's primary rights.
Yeah, but that argument gets us into the Section 4 territory, and at the moment you're arguing your specific performance ground of appeal. And on that point, can I just draw attention to what Lord Reed says in the second half of paragraph 81?
Yes.
Where he talks about the effect of the rule which Boston Harbour forbid shareholder is trusted management company at the right company's right of action to decision making organs, a point you made earlier. And then he says, if such a decision is taken otherwise than in the proper exercise of the relevant powers, then the law provides the shareholder with a number of remedies, including a derivative action and equitable relief from unfairly prejudicial conduct. So the question I want to ask at this point is, if we ignore Section 4 for present purposes, why is that not the answer to the specific performance claim, which is to say the company can bring the claim for specific performance, and if it doesn't, then the proper remedy is a derivative action or relief from unfair prejudice?
Well, my lord, this was exactly the paragraph that I had in mind when I answered an earlier of your questions. And you'll recall the point I made about Big never entrusting its primary contractual rights to anyone. So it didn't entrust any decision about exercising those rights to anyone, because the rights remained vested in it. They never passed to the company. The company simply acquired a statutory right to enforce the contract that is parasitic upon BIG's primary right. So ignoring the 1999 Act, my lord, while it might be true that BIG also has other remedies if SSPLC inappropriately decides not to enforce the contract, the existence of those remedies does not deprive BIG of its primary rights in contract. The rule in prudential isn't some wide-ranging discretionary rule that stops claims if there's a remedy through the company. It's a very narrowly circumscribed rule that only applies to stop the law recognising very specific types of loss. And so I come back to the point that because the specific performance claim doesn't depend on loss, it's no answer to it to say, oh, well, BIG could bring a derivative claim.
Yeah, but I think what I'm trying to get at is whether this argument is in truth dependent on your analysis of Section 4. And I appreciate you're coming to Section 4 in due course, and I understand in broad outline what your submission is there. But imagine the following variation of our facts, which is that the contract specifically provides that upon coming into existence, the company will have the right to enforce this obligation. So it's written into the contract ab initio, so one's not dependent upon the operation of Section 1. Why on that hypothesis would one not be saying, well, the right answer, if the company doesn't exercise that right of action, is for the shareholder to bring a derivative action?
So it would be the right answer as regards the claim in damages, but only the claim in damages. Because on those hypothetical facts, the future shareholder absolutely has agreed to give the company a right that's not dependent on the 1999 Act to enforce the contract. So the shareholder can't rely on Section 4, and the shareholder's claim for damages would be a claim that engaged the rule in prudential, because it would be a claim for share value loss and distribution loss. But the claim for specific performance would not engage the rule, because it has nothing to do with those types of loss. It's an independent right. So on my Lord Justice Arnold's hypothetical facts, of course, if a shareholder or future shareholder wanted to give all their rights to an as yet to be incorporated company, they could do so. They could contract on terms that the company would have the exclusive right to enforce the promises that were being made to them. That would bar the claim for specific performance.
But that would be by contract rather than as a result of the rule in prudential.
My Lord, yes, but your example would have been as the result of the company acquiring a right by contract. And my answer is really, well, one needs to construe the hypothetical contractual right. And the hypothetical contractual right that my Lord gave an example of would only lead to the barring of a claim in damages. I do not accept respectfully that any of my specific performance arguments rest on my 1999 Act ground, because the essential basis of the specific performance ground is that specific performance does not depend on establishing loss, and so it doesn't engage the rule. And of course, if I'm right about the 1999 Act, and my lady and my lords are with me on the hypothetical fiduciary duty claim, you strictly wouldn't need to consider the specific performance point, because the conferring of a contractual right, or a right to enforce the contract on the company, would never stop BIG, let alone Mr. Burgess, from being able to enforce the contract however they so wished. So in that respect, the specific performance ground is posterior to the 1999 Act ground. But I'm dealing with the specific performance ground first, because I wanted to show my lady and my lords all of the parts of Lord Reed's judgment where he emphasises again and again that the only effect of the rule is to stop certain types of loss from being recognised. I am ever so slightly concerned about timing, as very, very helpful as all these interventions have been, but I thought I ought to just say the interventions have, I'm fairly sure, had the result that I won't have to say lots of things that I intended to say, and I certainly won't repeat myself. But I just have that very slight concern, given I'm still on specific performance. It won't surprise you, however, to know that almost all of the legwork is being done on specific performance, because I'm not going to go back over Marex at all. So, my lady, my lords, My Lord Justice Arnold drew my attention to precisely the paragraph that I was about to draw the court's attention to, so paragraph 81.
Mm-hmm.
And I believe I said it earlier, so I won't repeat it in any detail. But the focus on in analysing whether the principal in Foss and Harbottle is engaged, the focus is on whether it's the company's right of action that is involved. And as I said, where one's looking at BIG's primary contractual rights, one just isn't looking at the company's rights of action at all. Those are not rights of action that were entrusted to the company's decision-making organs. And then 89, my lady, my lord, is just where Lord Reid reaffirms the approach adopted.
Before you do so, though, you've repeated that phraseology a couple of times, that the obligations, the rights of BIG were not entrusted to the company. But if one reads the agreement as a whole and what was intended, it was always intended that the company would be incorporated and that BIG would become a shareholder in the company. So the very agreement envisaged that situation in the sense of BIG and Mr. Burgess, by BIG, becoming shareholders in an entity which was to come into existence. Therefore, you might analyse that as saying, well, actually, it was always envisaged they would become shareholders and they would stand behind the rights of the company. But you're saying, no, always, in the light of this agreement, the individual promisee retains his primary rights, even though he was envisaging that in the future he would be the shareholder.
So first, there are three points that I'd make in response, my lady. The first is, my lady contemplated that being one possible analysis, and I'd say it would be entirely the wrong analysis to embark upon at the strikeout stage. So it's a matter for trial judge once the precise terms of the agreement are determined. The second point is, the second and third points are points that I've already made, I believe, in response to questions from my Lord Justice Arnold. But the first is, BIG was not contracting in its capacity as a shareholder. It was contracting...
No, it was contracting as itself, but with in contemplation of becoming a shareholder.
My lady, yes, but the reason why I repeated the not in its capacity as a shareholder point is because of my example of, well, what if it had transferred the shares away immediately? It had a personal right to enforce the contract, quite independent of the plan for it to become a shareholder. And the third point in response to my lady's question is again a point I mentioned, but no party contracted on behalf of SSPLC. They made a decision not to do so. They could have done so. And equally, on my pleaded case, there was no question of the kind of contractual referral of right that my Lord Justice Arnold contemplated. So for those three reasons, the fact that everyone contemplated SSPLC's incorporation doesn't derogate BIG's primary contractual right. My lady, before my lady's question, I had just been about to show you paragraph 89. And just Lord Reid saying he would reaffirm the approach adopted in Prudential, and by Lord Bingham, I would interpose parenthetically alone in Johnson. And then the punchline is the rule in Prudential is limited to claims by shareholders that, as a result of actionable loss suffered by their company, the value of their shares or the distributions they receive as shareholders has been diminished. Other claims, whether by shareholders or anyone else, should be dealt with in the ordinary way. So we know from Marix, anyone other than a shareholder isn't caught by the rule of Prudential. But even a shareholder is only caught by the rule to that very limited extent. and a claim for specific performance simply doesn't engage the rule as explained. And just very briefly, my lady, my lords, just to show you, Lord Hodge, as you would have seen from your pre-reading, gave a short concurring judgment. And I would just ask you to note, if you haven't already, highlighted paragraphs 99 and 100 of Lord Hodge's concurring judgment. And the key point is the first sentence of paragraph 100. So that is the full extent of the rule, my lady. And in my submission, properly understood, the rule can therefore never apply to a claim for specific performance. And I mentioned Bezic and Bezic. I've already explained the facts to you. Sorry, I want to take you to the case in the hard copy bundles. I'd been labouring under the misapprehension that you were working from electronic copies, but tab 7 of bundle 1, I hope. I hope that I summarised the facts accurately. They are at 71 for your ladyship's note, 70 to 71, sorry. And really the key point is stated most clearly by Lord Reid at the bottom of 72. And you'll see, applying what I've said to the circumstances of the present case, and if you'd read just to the bottom of that paragraph at letter B, please. Sorry, letter C. So Lord Reid rejected the argument that the administratrix could not obtain specific performance of the contract because in that capacity she had suffered no loss. And by analogy, I say this applies to BIG's claim, even on the hypothesis that the law does not recognise BIG's loss. If the law does not recognise BIG's loss, it still has a right to claim specific performance of the contract. And further support for that it is derived. If my lady will forgive me, just given the time, I'll just mention the passages rather than take you to them. But also in the speech of Lord Reid at 77G. And then in the speech of Lord Hodgson at 82C. And actually I ought just to read what was said on behalf of the appellant, that the personal representative could not obtain specific performance as the estate had nothing to gain, having suffered no loss. And Lord Hodgson said, there is no authority which supports this proposition, and I do not think it has any validity. So the suggestion that specific performance required loss is a proposition with no validity. And finally, 89, in the speech of Lord Pearce, at B to C, the defendant on his side has received the whole benefit of the contract. As a matter of conscience for the court to see that he now performs his part of it. So it's a further policy rationale for specific performance not depending on a promisee establishing loss. And because specific performance does not depend on a promisee establishing loss, the rule in prudential does not bar a claim for specific performance. Nowhere in his judgment in Marix does Lord Reed say that the rule in prudential operates to divest a shareholder of a right of action or a cause of action. To the contrary, he is at pains to demonstrate or emphasize that the rule is only about the non-recognition of certain types of loss. Claims for specific performance are claims to vindicate a contractual right. They are not claims for loss. So some academics try to talk about rights or the loss of rights as a kind of loss, but that's nowhere contemplated by Lord Reed in Marix. Lord Reed is specific and precise in the types of loss that he says engage the rule in prudential. And I won't take my lady, my lord to it, but as you'll be aware, a claim for specific performance does not even depend on showing that a right has been breached. Not only do you not have to show loss, you don't even need to show breach of a contract in order to claim specific performance. And the authority for that proposition is Hasham and Zenab, which is in the authorities bundle. So I'll just give you a reference for your note. But so at tab 6, and I won't give you all the references. I might deal with this in reply if it becomes controversial, but really it emerges squarely from the very opening of their Lordship's judgment, which was delivered by Lord Tucker. It's at page 329. Their Lordships are of the opinion that the fallacy of the submission, this is the submission that you'll see at 320, that because there was no relevant breach, the jurisdiction to grant specific performance was not brought into play. That's about a third of the way down on 320, just for your note. And Lord Tucker says that the fallacy in that submission consists in equating the right to sue for specific performance with the cause of action at law. This is another part of one of the answers to the claimant damages, which is a cause of action in law, is just independent from. It was a fallacy to conflate it with the claim for specific performance. The claim for specific performance is about inviting the court to intervene where its conscience requires it. And so because of that, one did not need to show breach in order to succeed in a claim for specific performance. One didn't even need to show breach. So of course one doesn't need to show loss.
And if you could just repeat the reference, it's page
329,
Yep.
my ladies, and the reference back to the submission is at 320. The submission is at 320.
Thank you.
And my lady, as I said, I might
Yes.
deal with this further in reply if I need to do so. But there are other relevant passages of the judgment of Lord Tucker. But that really says all I need to say for present purposes. So
I think we need to move on.
my lady, my lords, I was just about to say, unless I can assist further on ground 2, I was just going to move on to ground 1, which will be considerably briefer, and my submissions become ever more brief, depending on interventions from the court. And as I said, I will try hard not to cover old ground or repeat myself. As I said to my Lord Justice Arnold, if SSPLC were party to the agreement, I might be in difficulty. I do not accept that I would be. In my submission, contracts are a case apart, but I do not need to persuade the court of that on this appeal, because SSPLC was not a party to the agreement. The breach of the agreement was a primary wrong against the promisees to the agreement. These were BIG and Mr. Burgess. So absent Section 1 and ignoring the hypothetical fiduciary duty claim, the company would have no cause of action. Because the wrong is done to the... Sorry, I saw my lady proud us. Because the wrong is done to the shareholder, not the company, the shareholder has the cause of action, and therefore, we just looked at it in Marex. There is no reason why the shareholder should not recover its loss by means of award of damages in accordance with ordinary principles. That's Marex at 45. And as my lady, my lord saw, that expressly includes loss, share value loss and distribution loss. There are, in my submission, 8 steps to the conclusion that the conferral of a right on SSPLC by Section 1 cannot engage the rule so as to bar BIG's claim for contractual damages. And I was grateful, my lady, for your indication as to pre-reading, but if I might just take you to my skeleton argument at tab 3 of the core bundle at page 32. The 8 propositions are there enumerated. So if I might invite the court just to read those propositions, and I'll make a few remarks about some but not all of them.
So the linchpin of the argument is actually point 8, isn't it?
Well, my lord, point 8 is very important. Point 6 it is also, in my submission, crucial, because one looks at Section 4, which is a very, very brief section at page 6 of the Authorities Bundle at tab 1. And it provides, without exception or caveat, Section 1 does not affect any right of the promisee to enforce any term of the contract. And
well, I understand your point that Section 4 is unlimited in its terms, for sure. But the whole question is, in what way does the rule and prudential apply? And you say, well, it only applies because of Section 1.
It only applies because of Section 1. That's because unless you accept the hypothetical fiduciary duty ground, which I've submitted, you shouldn't for the reasons I outlined, and I'll flesh those reasons out in as much as it will assist the court and as much as time allows. But it's absent that, which I say isn't open to my learned friend on this appeal, it's entirely dependent on Section 1. That's why I call Section 1, as interpreted by the learned deputy judge, a parasite that kills its host. And it can't be. It can't be because Parliament said it never, ever could be. The parasite and the host can happily coexist, but the parasite does not kill the host, even if the parasite happens to be a company and the host happens to have a share in it. Because the logic of my learned friends and the learned deputy judge's interpretation of the Act is that even one share would do. BIG had a solitary share, so stood to gain almost nothing financially. It could not bring a claim in specific performance because of the rule in prudential. And that, in my respectful submission, does violence to the clear and explicit intention of Parliament in enacting Section 4. And I don't just rely on Section 4, I rely also on Section 7. And I rely in particular on Section 7.1. This is at page 8 of the Authorities Bundle. It provides that Section 1 does not affect any right or remedy of a third party that exists or is available apart from this Act. So when one reads Section 4 and Section 7.1 together, the clear intention of Parliament was to prevent the conferral of a right by Section 1 from having any effect at all other than giving the conferee a right under Section 1. And I say that is right as a matter of conventional statutory construction, and the then Deputy Judge, with respect, was wrong to look at the Law Commission report. I say actually the Law Commission report helps me rather than hinders me, but I'll deal with that in reply if necessary. But when one considers what a radical change the 1999 Act involved, it is entirely to be expected that Parliament was trying to minimise the disruptive effect of Section 1. So the right was confined, strictly confined, to giving a third party a right to enforce a contract in certain circumstances. And it never affected the right of primacy, and it never affected the right or remedy of a third party. So the Act was seeking to do the absolute minimum required and to have ideally no unforeseen or unwanted side effects. And I say the learned Deputy Judge's interpretation that Section 1 engages the rule in prudential would be an unwanted and uncontemplated side effect that would run contrary to the clear wording of Section 4 and Section 7, but also the objective intention of Parliament as it should be ascertained. And my lady and my lords might, if in the unlikely event that they have an idle moment, will see in Beswick and Beswick that Lord Reid deprecated the fact that the Law Commission had been saying since 1937 that third parties should get rights to enforce contracts under certain circumstances, and hoped that that day would come soon. But his hope was eventually realised, but some 39 years later. But it demonstrates how significant a change it was. It was a change that the common law was crying out for, and yet it was a change that Parliament deliberately, closely confined the effects of.
And in the 2 decades or so since, there's been a surprising dearth of authority dealing with the 1999 Act.
My lord, no one in any reported case that I've been able to find has ever even sought to argue that the conferring of a right by Section 1 bars the right of a primacy by any means, because it's not an argument that's maintainable because of Section 4.
And turning that round, what about the point that if you're right about Section 4, that might do grave damage to the rule in prudential?
Well, my lord, it's entirely artificial in my respectful submission, respectful to my learned friend. My learned friend tries to run a kind of floodgates argument and say, well, if I'm right, then there'd be no end of litigation by shareholders who were parties to contracts where the company wasn't a party to the contract. There wouldn't be a raft of that litigation because as my Lord Justice Arnold observed, this just isn't a case that seems to have arisen before. In George Fisher, it arose. That was a pre-1999 Act case, one that Lord Reed expressly approved, and one that I say should give my lady and my lords great comfort, because it's entirely consistent with what I say the scheme of the 1999 Act is. The rights of a shareholder promisee just aren't affected. The rights of a shareholder contractual promisee are inviolate, they're not entrusted to the company. And even though, as in George Fisher, the loss is share value loss and distribution loss, the shareholder is entitled to.
So can I just articulate that point to see if I've understood you correctly? Do I understand the point you just made to be that it would be highly surprising if the 1999 Act has the effect of borrowing the claim that was recognised in George Fisher?
My lord, yes. It recognised in George Fisher and expressly approved by Lord Reed. It just didn't change anything as regards the position of a promisee. There's no way of getting round Section 4 in my respectful submission and an answer to my Lord Justice Coulson's question. There is no floodgates argument that possibly helps my learned friend. In contrast, if Section 1 and Section 4 read together with the rule in prudential, had the effect for which my learned friend contends, it would have radical and disruptive consequences for commerce. The reason for that is it's commonplace for a holding company to enter into a contract, the performance of which will benefit its subsidiary. One need only think of a maritime context. If the construction of the 1999 Act for which my learned friend contends were right, the rule in prudential would operate to divest the holding company of the right to enforce the contract that benefited its subsidiary. That would be, in my submission, contrary to commercial common sense and would rob the 1999 Act of its intended practical effect. It would also generate very substantial and entirely avoidable uncertainty. I said already that the learned deputy judge's interpretation of the 1999 Act it is hard to reconcile. I would say impossible to reconcile with well-established tenets of the law of contracts. A promisee ought to be able to enforce a contractual promise made to them.
We have to be slightly careful about that, because you could say that about the rule in prudential.
I could say that about the rule in prudential, but only up to a very, very small extent.
Well, I appreciate it's limited to the question of the losses, but if you're looking at it simply as can a promisee enforce, usually, of course, the answer is yes.
Well, my lord, I say always if the promisee is a party to the contract and the company isn't. And I also say, actually, even if the company is a party to the contract, that shouldn't prevent the promisee from enforcing, but I don't need to persuade my lord and my lady, my lord, of that today. But we're dealing specifically with, because why I say contract might well be a case apart, but I don't need to prove that today. And there aren't other cases. It's another problem with my own friend's floodgate argument. When a tort's done to a company, or when an equitable wrong is done to a company, the company has a cause of action, the shareholder does not, if it's in respect of the prohibited losses under the rule in prudential. And my Lord Justice Arnold's point comes into play that the shareholder might have a derivative claim or might have an unfair prejudice remedy. Contract's different because one's looking at the rights of the shareholder promisee, and specific performance is different again because it has nothing to do with loss. I alluded to the commercial and conceptual difficulty with the learned deputy judge's interpretation of the 1999 Act. I won't take you through it, but if I could just remind you of paragraph 64 of my skeleton at page 37 and invite to read that in due course. That is just saying in a bit more detail what I said to my Lord Justice Arnold very close to the start of my submissions, namely that there would be this unreality and very odd set of different circumstances if initially Big could enforce the contract and then at some point became incapable of doing so, and present the court with an unprincipled and unjustifiable difficulty in deciding what remedy to grant if specific performance was sought. So it's really the parasite that kills its host, my lady. It can't be that. And so for that reason, ground one of my appeal should be allowed in my respectful submission. I'll deal as quickly as I can with the hypothetical breach of fiduciary duty claim. I won't repeat the points that I have made. Whether Mr. Smith breached his fiduciary duties by failing to perform his obligations under the agreement, which are obligations that he owed in his personal capacity, obligations that he assumed before the company was even brought into existence, whether he breached his director's duties is a highly fact-sensitive question.
But why is that correct? Because don't we, for these purposes, simply assume that the facts that you plead in the particular claim are true, and then examine what the legal consequences are?
Well, my Lord, absolutely the facts in the particular claim are true, but they are not exhaustive or comprehensive facts, my Lord. And one doesn't know, for example, what disclosure or evidence might reveal as to discussions that were had internal to the company, or Mr. Smith's reasons for declining to discharge his personal obligations. That is one reason why I say the judge was well within his discretion in deciding to leave this as a matter for the trial judge. But I see my Lord Justice Arnold found it's not, I don't hang my hat exclusively on the fact sensitivity of the breach question. The remedy question is both fact sensitive and legally complex as well. First of all, there's the obvious point that specific performance isn't a remedy that's available for breach of fiduciary duty. So the existence of a breach of fiduciary duty claim can't possibly bar a claim for specific performance or damages in lieu of specific performance. Those really are ships passing very far apart in the night. But further, other remedies are available in contract that aren't available in breach of fiduciary duty and vice versa. And also, my Lord, consider this hypothetical. Mr. Smith realizes that not performing his personal obligations would involve a breach of fiduciary duty, which, by the way, I don't accept, and then resigns. He instantly resigns. As soon as he has that realization, he resigns, so he no longer owes duties as a director. It must at least be arguable, and one imagines a hotly fought claim where he is seeking to defend himself and say he's not liable to make the company whole and put the company in the position it would have been in had he performed his personal contractual obligations. One can imagine him saying, well, the only loss that my breach of fiduciary duty caused really doesn't sound in equitable compensation, because by resigning, I brought my breach of duty to an end. It's about the conflict rule. When the conflict arose, I resigned. And that analysis is made good by considering a director, different facts from this case, a director who just happens suddenly to become under a conflict, where he's personally obliged to perform a contract that would benefit the company of which he's a director, but he doesn't want to do so. If he instantly resigned, in my submission, it's at least well arguable that the company wouldn't have a claim for equitable compensation to put it in the position that it would have been in had he performed his personal contractual obligations. And if my lady and my lords think it is well arguable, that's a yet further reason why these kinds of questions should be determined on facts as found at trial, not on hypothetical or assumed facts that do not have the detail or the nuance that, of course, the findings of a trial judge would or might involve. So, in my submission, it was plainly appropriate and indeed desirable for the effect of the hypothetical fiduciary duty claim, which had hardly been articulated before the learned deputy judge, to be left for the trial judge. And it's also borne out by parts of Lord Reed's judgment in Mareks. You'll remember me having emphasised the word normally about the application of the rule. And I'll return to it in reply, but he also refers to the question of whether the rule is engaged, sometimes in requiring the exercise of judgment. So, my lady, my lords, have the point that the defence just wasn't before the court when the learned deputy judge decided the matter. So, in my primary submission is Mr. Smith should not be permitted to rely on the defence. But if, contrary to that, the court is minded to engage with the hypothetical fiduciary duty claim, it could not safely conclude at this stage that the possible existence of such a claim bars even BIG's claim in damages, and it certainly can't bar either BIG's or Mr. Burgess's claim for specific performance, because specific performance isn't a remedy for breach of fiduciary duty, and specific performance does not depend on establishing any loss. This is another respect in which the timing is significant in response to my Lord Justice Arnold's point.
Well, and we go around section 1, section 4 circle again.
Well, I wasn't proposing to do that, don't worry, my lord. But what I was going to say is that it's part of what we teased out about SSPLC acquiring a right immediately on incorporation, but not a cause of action immediately on incorporation. So it acquired a right under the Act immediately on incorporation. So there's no need to impose or imply a fiduciary duty obliging Mr. Smith to do what the company was entitled to oblige him to do as a matter of statute. The company's interests were instantly protected by Section 1 of the Act. The moment it winked into existence, there it was with its right under Section 1. So the imposition or implication of the kind of fiduciary duty for which my learned friend contends would add nothing to Mr. Smith's pre-existing obligation under the contract by operation of Section 1. And I will just be a couple of minutes more if my lady will give me that indulgence. Just really to highlight again to my lady and my lords the steps or the reasoning set out at my skeleton at page 39, paragraph 72.
Your point is that they once again can come round to the fiduciary duty, relying for its existence upon the contract, and so you're back around the circle. I'm not proposing to go round my Lord Justice Arnold's circle again, but it's just another parasite that would kill its host, and that emerges from step 1 of my reasoning. It's not the director's not obliged to just transfer his property if the company encounters cash flow difficulties. Obviously, there has to be something else that obliges him to do so. So the duty to act in the company's best interest doesn't have that onerous an effect. The only thing that required performance was the acquisition, was the agreement. Absent the agreement, Mr. Smith would not have owed the transfer obligation. And he would not have owed the transfer obligation to the company, absent Section 1 of the Act. Mr. Smith appeared to recognise that the hypothetical fiduciary duty claim depended on Section 1. And just for my ladies and my lords' note, that's paragraphs 36 to 38 of Mr. Smith's original skeleton argument in the supplemental bundle, tab 4, at page 75. So my lady has the point. If the hypothetical fiduciary duty claim barred BIG's primary
contractual claim in damages, it would just be achieving by a side door what Parliament said by Section 4 could never happen. I don't propose to say really much at all in addition regarding the Russian doll fallacy. I'll come back on it in reply if it will assist the court. But I would just note, first of all, that my position, I've explained how the appeal could be disposed of in a sentence. I won't repeat that. To put it another way, the learned deputy judge was right to decline to strike out Mr. Burgess's claim, which I remind the court is only a claim for specific performance or damages in lieu of specific performance, for the reasons that he gave. Those reasons are at paragraph 61 to 65 of his judgment. Those reasons are unimpeachable. That's Core Bundle, tab 7, pages 91 to 93. And again, just for my lady's note, I said Lord Hodge refers to in his concurring judgment the rationale for the rule only applying to shareholders. And I'll return to reply if it would assist, but just to note and highlight paragraphs 102 to 108 of Lord Hodge's concurring judgment, where the justification of the rule in Prudential entirely depends on what Lord Reid described as the unique position of the shareholder as regards the company. That is not the position that someone who happens to hold shares in a shareholder shares. So Lord Reid explicitly limited the application of the rule to claims by shareholders in the relevant loss-suffering company, and for that reason alone the cross-appeal must fail. And I would just remind my lady and my lords of where I deal with this in my skeleton, but in particular paragraphs 83 to 85 on page 41 and 42. In advancing his cross-appeal, Mr. Smith sets up a false distinction between natural shareholders and corporate shareholders, asserting that the former would always be barred by the rule of Prudential, whilst corporate shareholders would practically almost never be barred because they could simply procure one of their shareholders to bring any claim. That's paragraph 49 of Milo and Friends' original skeleton argument. It is obviously not always or almost always the case that whenever a corporate shareholder has a claim against a company, that corporate shareholder can or will have a claim against the company. When one comes back to a contractual setting, one can see how unreal the submission is, because BIG can't procure another company to bring its claim under the contract. Only it has a claim under the contract. And the floodgates argument just doesn't run at all for that reason. In summary, the rule in Prudential is something which a shareholder contracts into upon acquiring shares in what proves to be a loss-suffering company. But that reasoning cannot apply to a second-degree or third-degree shareholder who does not acquire shares in the relevant company and therefore never contracts into the rule so far as it affects recovery of losses by that company. To hold otherwise would first ignore the privity of the relationship between the shareholder and the company, and second, the doctrine of separate corporate personality as restated in Prest by the Supreme Court. So for those reasons and the reasons explained in my skeleton argument, if Mr. Smith's cross-appeal arises for consideration, which it should not, it should be dismissed. My lady, unless I can assist you further, those are my submissions by way of opening.
Thank you very much indeed.
I'm very grateful.
Mr. Sullivan.
I'll take the various matters before the court in the same order as my learned friend. So first, the specific performance appeal. One preliminary point is just to identify the wrong, which is the subject of this claim. What is complained of in this claim is it's alleged that Mr. Smith failed to transfer assets to SS plc. Now, on the specific performance ground, I just refer your Lord, Lady and my Lords, first to paragraph 34 of Lord Reed's judgment in Marex, which is behind tab 17 of the authorities. An introduction to that paragraph. Paragraph 33, which I'm not inviting you to read, is the paragraph where Lord Reed explains why the rule against double recovery is an insufficient justification for the rule. And if the court could read paragraph 34.
Thank you.
This forms part of the company autonomy justification for the rule, which Lord Reed explains further later on in his judgment. Then at paragraph 35, there's an analysis of the rule in Foss and Harbottle, as restated in Prudential, which Lord Reed tells us has two aspects. First is that the proper plaintiff in an action in respect of a wrong alleged to have been done to a corporation is, prima facie, the corporation. As was explained in Prudential at page 210, one of the consequences of that aspect of the rule is that a shareholder cannot, as a general rule, bring an action against a wrongdoer to recover damages or secure the relief, I stress that, for an injury done to the company. So that's the first aspect. And then the second aspect, which is explained by Lord Reed towards the bottom of the page, is again that company autonomy point. So a shareholder, when he acquires his share, entrusts the management of the company's affairs to the decision-making organs under the articles, so usually the board and the general meeting. And those decision-making organs have the right to decide how the company's investments are protected. That includes the right to decide how any causes of action to protect those investments are dealt with. Then paragraph 36, which is really part of the core of the rule. So where a shareholder claims that his shares have fallen in value as a result of a loss suffered by the company, and the company has a right of action in respect of that loss, the shareholder can exercise such rights of control over its decision-making as have been granted to him by the Articles of Association. So the company has to have a right of action, of course, but there's no distinction in Marex or in any other decision on reflective loss that I've been able to find between different causes of action. No cause of action is better than any other. All that's required is that the company has a cause of action. And so my learned friend's analysis, where he draws a distinction between a primary right and an ancillary right or a secondary right, is not to be found anywhere in any of the authorities. And then to conclude paragraph 36 is a point that Lord Justice Arnold made concerning the possibility of other remedies such as a derivative action. And there's also a reference to a section 994 petition. And then finally in this section, paragraph 37, Lord Reed noted, and as the court observed in Prudential, that to allow the shareholder to pursue a personal action would subvert the rule in Foss and Harbottle. And he points out that's not just a theoretical concern, there are practical consequences of that. It prevents a the existence of concurrent claims could result in the shareholder preventing the management from dealing with the claim in the way that they consider it in the best interest of the company. That would undermine the rule in Foss and Harbottle. And the example that he gives is if the company wants to compromise the claim, but the shareholder doesn't. Well, that would impact on the company's right and the company autonomy points. And then he also points out that there'd be a difficulty if the if the wrongdoer rather has inadequate assets to satisfy both claims. And then finally, insofar as Marex is concerned on this ground of appeal, paragraphs 52 to 54, which my learned friend has shown the court. Paragraph 52 begins with Lord Reid noting again, as he did earlier in paragraph 33, the problem with reasoning based on the rule against double recovery. And he notes that part of the problem there is that principle, the rule against double recovery, is one of the law of damages. But the prudential principle is all about identification of the shareholder's loss, which is a point my learned friend made. Now, true it is that paragraph 52 begins with addressing the problems of analysing the rule against reflective loss by reference to double recovery. But Lord Reid goes further, because by the time we get to the end of the paragraph, he says this device has been exploited in a number of cases subsequent in ways which circumvent the rule in Foss and Harbottle, a rule which is not confined to actions for damages, but also applies to other remedies, as explained at paragraph 35 above, which we looked at a moment ago. And then,
yes, I'll just pause there, because I'm interested in that observation, because one suggestion which might be put forward in that light is that actually the entire discussion about the applicability or otherwise of prudential is irrelevant to this case, because this is not a case about damages, it's not a case about losses, it's about who can bring the claim. And that what we should really be focusing on is the rule in Foss and Harbottle. What would you say?
well, I think that's probably right, my lord. But the way that Lord Reid analyses prudential is that it is effectively a manifestation of the rule in Foss and Harbottle. So I think Lord Reid may say that we would be talking about the same thing there, that the reason for prudential is Foss and Harbottle. And when one is looking at loss and injury, to use Lord Reid's phrase in paragraph 35, in my submission, what the court has to do is look at the reality of the situation, look at what is in fact the case, and not be constrained by careful pleading.
Well, that's an apposite warning, indeed, but let's pursue that thought a little further, because we're trying to find the right principle here. So imagine that the case was one for specific performance only, with no claim whatsoever for damages in view. Now that would highlight the argument that this is nothing to do with damages, nothing to do with loss, it's all about enforcing contractual performance. Now, if it's all about enforcing contractual performance, what's prudential got to do with it? Foss and Harbottle might have something to do with it, but it's got nothing to do with prudential.
Well, in my submission, it has to do with prudential because even if, for whatever reason, the claimant decides, I'm only going to plead a claim for specific performance without any plea of damages in lieu, and query whether that would prevent them claiming damages in lieu anyway, but even assuming for the time minute that it did, the court still, in my submission, has to ask, well, what's really going on here? And in the present case, the answer to that question is, what's really going on is that the injury that we're talking about in this case is plainly an injury to SSPLC. What's being complained of is a failure to transfer an asset to SSPLC. Why is the claimant bringing the claim? They're bringing the claim, in this case, because they feel that they've suffered a loss. And the loss that they have suffered is a diminution in the value of their shares, and they say a loss of dividend issue. Now that would be the reality, whether or not the claimant pleaded a claim for damages, and whether or not it pleaded a claim for damages in lieu. So to answer my Lord's question, I'd say this is about prudential, if that is distinct from Foss and Harbottle. Of course, the court has to look at the actuality and not the, and the claimant can't circumvent.
Is what you just said necessarily correct? Suppose they get non-specific performance. So the assets are transferred to the company, which we know is in liquidation. And then if it's a solvent liquidation, I mean, obviously if it's an insolvent liquidation, then nobody gets anything. But let's assume it's a solvent liquidation. Then those who are entitled to distribution will get, and those who are not entitled to distribution won't. What's wrong with that?
Well, my Lord, but again, the purpose of the action is to remedy a perceived loss on the part of the shareholder. And I accept my Lord's point. It may turn out at the end of the day that there is no loss, but that's not the claim that's put. The claim that's put is that there is a loss. And the points that my learned friend makes are points that could equally have been made to say that the decisions Lord Reid cites in paragraph 53 of his judgment were perfectly proper decisions. But in my submission, it's clear that Lord Reid considered that those decisions were all devices which circumvented the rule in Foss and Harbottle. And I don't accept my learned friend's suggestion that one can read into paragraph 53 any suggestion that Lord Reid hadn't properly considered these three cases. In my submission, I mean, even if that was a proper argument to begin with, in my submission it's clear that when one reads paragraph 53 that Lord Reid has carefully considered each of the cases and their facts and has drawn the conclusion that he drew. Lydia, my next point was to take the court through those three cases. I wonder whether, in view of the time, that might be an appropriate moment.
Thank you, Mr. Sullivan. I know that you've already been shorn of a little bit of time. Are you going to be able, nevertheless, to finish when it was proposed you would? Or
I'm hopeful that I will.
I'm just wondering whether we need to continue now or we need to start a little bit early before 2 o'clock.
Well, my lady, I think that I'll be able to finish in good time in any event.
Just hoping, giving you a little bit of leeway if necessary.
I'm grateful, my lady.
Thank you very much then. 2 o'clock.
We're still on live stream for 5 minutes.